welcome comments to those meetings and if appropriate, approve those meetings. Have we all had an opportunity to review? And if so, is there a motion?
This is Mike. I move we approve.
Is there a second?
A second.
All in favor?
Something was wrong with the text. That's why you weren't in. I'm making food.
All opposed?
You making food? I'm making biscuits for her.
Here's the motion carries, and we'll make the records the minutes part of the record. This morning's discussion will largely revolve around fines and fees, knowing that we've already sent up a preliminary recommendation that the court issue a rule directing inquiry on ability to pay. One of the things I hope to come out of this conversation is a commitment to go further than that preliminary recommendation. One goal might be the elimination of some or all of these fees, justified simply because the court provides an essential product, and that's justice, and query whether or not it's appropriate to have the range of user fees that are assessed to those citizens who are called upon to participate in that justice process. But we do have a full agenda. Mercedes, let me just ask you if you've heard from or whether Christina is online.
I have not. I was just messaging Ellen to see if she could check with her. We've got a couple more minutes. We were going to talk about the survey a little bit, and so hopefully she will be able to jump on by the time we get to her presentation. And if not, I can jump forward and talk about some stuff until she does jump on, or we can invite
Very good.
Professor Markham. Mm-hmm.
Well, good. Karen and Michael, Friday was an extraordinarily challenging and full meeting of the task force, and I think we're all looking forward to this opportunity to discuss some of what all happened. So Karen and Michael will send this item to you for facilitation.
All right, well, good morning, everyone. So yeah, there was a lot that went on. And so before we start talking about the survey a little bit, just overall reactions to Friday in terms of things that you heard, in terms of the presentation that we had from Work Group 4. So I'm just going to spend just a couple of minutes opening that up for reactions. Mary.
Okay, so first I was really impressed with the presentations by all the work groups, and I need to go back and digest some of what all was presented by them, because it was coming fast and furious. In terms of our presentation, I have a couple of comments. And maybe I missed something, but I thought we were only presenting the jury recommendations on Friday. So I was kind of unprepared to speak on the rest of it. And if that's on me, I apologize, but I look back and I thought we were just doing the jury stuff. And then the other issue that I just wanted to raise was that if we're throwing up slides that are being presented as work group product, I think the entire work group should have the opportunity to vet them and comment on them in advance. I mean, everything, it was, I think they went up fast and they looked basically fine, but I guess I'm persnickety sometimes about how things are phrased and presented. And I know we all are, lawyers tend to be, and we are supposed to be presenting a consensus product. So I'm not meaning to fuss at anybody. I just wanted to put that out there. And if I missed something, apologies. But so that's all I wanted to say.
Thanks, Mary. Appreciate that. And Mercedes, any comment or?
I definitely heard, I've heard that. And well, what we're trying to do is a lot. And I think a lot of the information is being kind of replicated from other sources that are out there. I understand that it is, like somebody described it, it's, like drinking from a fire hose. And so I think it's I can understand, how why we need to slow down. What I do worry about making. There's a quick turnaround, right? We're having meetings, so it seems like every week, and so I can appreciate for stuff going to the full task force, getting everybody's input before that. But I think it might be difficult, and I definitely am open and want to make sure we get the process down so everybody is clear and agrees with what we're presenting.
Thanks, Mercedes. And as you said, point taken. And thanks, Mary, for bringing that up. Others, reactions to the meeting on Friday and or our presentation?
I guess, yeah, I would just sort of comment to extend and emphasize what Mary said, is that we call on leaders for a very special reason, and that is for them to commit their full participation, their integrity, their background into the process. And one of the things that I will certainly do a better job of, and that we as a workforce, as a work group, will do a better part, is to ensure that each leader, each member has a full opportunity to see what goes out under their name. And this is more than a process issue. It's a commitment that we make to each member. And I think, well, you know, that has to be a priority for the work product going forward. And even as we look towards a full agenda in the weeks to come, we will feel pressure to get the output done, but we can't let that pressure change some fundamental principles of how we operate as a work group. And I think that's an important comment that we all must be vigilant to, and I certainly take that.
All right, well, sounds like a feedback is well taken, and that'll be something that we all work on, and making sure that not only do we get the information, but definitely process it so that we are prepared. So anybody else before we move on to talk a little bit about the survey? But I do want to say, taking a little point, Mercedes, I have to tell you, I really appreciate when I do send you a note and say, can I get, would you send? You are right on point. So I just want to give you that acknowledgement as well. So anyway, all right, so survey results. You know, the survey was given, I believe it was a week before the actual task force meeting. And so the results, Mercedes, I know that you sent them to me, but are these things that we could flash up by any chance?
Of course, yeah. Let me get on that real quick.
And I wanted to, but while Mercedes is pulling that up, these are the survey for us to sort of circulate our ideas, or the working group to circulate their ideas around the things that Mercedes was presenting on at the work group meeting on Friday. And so wanted to get some ideas as to whether or not that format worked for folks. Was that a good way for folks to share their ideas? And after that, perhaps we can speak to some of the concerns or some of the things that folks flagged as perhaps maybe obstacles for bringing some of those recommendations up to the task force. So first, did the survey work for folks? Was that a good method for capturing your ideas and your feelings about how to move forward?
I'll speak to that, Michael. I mean, I think it's probably the most efficient way to get our input. So it definitely worked for me. Thanks,
Brooke. Appreciate that. Thank you.
Michael, this is Mike. I agree. I thought it was straight. It was easy to understand, and the questions were straightforward and clear, and it worked for me too.
Great. Thank you, Mike.
But it was, I echo or agree with both of those comments. I was incomplete in one of my responses, and I tried to go back and fix it, and I couldn't figure out how. So, but that was user error. Overall, I think it's a great system.
Right.
I've got like multiple screens pulled up here, but this one is they call it the back end, right? It pulls into an Excel sheet, and then this questions are here, but you guys should be able to see the responses in a little bit more user-friendly format. But what I did was kind of I went through here, and just to speak real briefly, the majority of all of them were 5s. I kind of highlighted there were mainly 4s and 5s for most of what we were doing, and then a lot of questions about kind of the need to articulate more on the budgetary aspect of things and data, which we have a lot of data in the reports that were submitted on fines and fees to support a lot of this. The budget question is obviously always a question, but I can scroll through here if you'd like, and if anybody wants me to pull up a specific question or one thing I do want to mention really briefly is that there was one recommendation regarding the disenfranchisement of individuals with felony convictions that did not get consensus. That being said, I think that this issue is actually addressed when we talk about fines and fees, and maybe possibly addressing fines and fees in parole and probation in that angle. So I don't necessarily think that we need to go back to that recommendation unless the work group wants to.
But is that in litigation right now?
It could be, yes. I've heard rumblings of that.
Yeah.
I was Miss Becker if she's not on the line yet, she can speak.
Oh, okay, never mind. I forgot she was. Okay, she'll know.
Yeah, she'll know, and she was going to send me some information on that. But there she is. Yes, Miss Becker, go for it. Christina, thank you. You're muted.
I actually don't know where they are right now. I know that it was. It's kind of going back and forth where it won and then got shot down and then won again. And I believe it's up at the Supreme Court, but I'm not positive where it is right now, but I'm actually taking a look. So.
Thank you.
Mm-hmm. I believe that it's passed.
All right, so it sounds like the survey worked for everyone, and definitely it contributed to the report that we had. So I guess the other question that I would have is if in terms of the other recommendations that we had, if there's any more feedback about that, or is there something we need to discuss even further?
I had a couple of thoughts, and I talked with Henderson about this in terms of maybe tightening up the problem statements and the value-oriented future statements as being more specific to the issue that's being addressed. And we don't need the wordsmith right now, but that was one observation, to make them specific to the issue that comes after them. And we can, I don't know what the proper venue that is. We can go into that a little more. The other was on the fair sentencing versus structured sentencing. I think it would be helpful to have a little more data there. Mary may have that. I see her shaking her head, because the numbers are very compelling in terms of the disproportionate impact on minorities. And I think if you've ever spoken with Tom Ross about this, I mean, the issues that were present with the reform to structured sentencing, we're seeing some of that again. And I think we need to remind ourselves of that. With regard to the Batson issue, I had thought about and have heard a number of folks talk about some specific language, not only allowing jurors to self-identify, which I think is critical as to race, but also allow attorneys to identify through affidavit or otherwise. You know, we allow lay witnesses currently to do that, and some specific language that would allow both of those things to happen, not one to the exclusion of the other. But I'll be quiet.
Thank you. Thank you very much.
Let me comment on some of what Alan had to say. One is the notion of the problem statements and how we do some of the refinement that he suggested. And I think this tags to what Mary said about, you know, we feel compelled and we're responsible for the language to which we're voting. And so I would encourage offline exchanges, redlining of problem statements so that we actually get the clearest understanding of what each member thinks about a particular proposal. It also points the way to where we may need to edit and supplement and change either the language or modify the actual proposal. But I think using redlining or tracking to identify your suggestions is really most helpful.
We can definitely do that using our SharePoint page. You know, the recommendations are up there right now, and anybody, you know, we can, moving forward, use a process to do that before we propose any recommendations, obviously. But even now, today, actually, this week, you guys are going to get Word versions of the proposals that we sent out, and I invite you to edit them directly on the PowerPoint or on the SharePoint, or send us a redline version back, and we will incorporate those edits. You know, I am all about feedback, and a lot of the language that came directly from the reports that were presented. And I am more than open to having people help draft the language of these things. I think what happened was a feature of trying to push something through, which what I thought we had a general consensus on, and so trying to get something through, but that being said, we will slow things down, and please give input on these documents when they're on our SharePoint.
Right, and I think it's a good idea to send those out to people, and I mean, you can direct them, like you said, to the SharePoint, but also it's nice to be able to have those right in your mailbox, so that you can, and you know exactly that it's there. So, well, good. All right, sounds like. Thank you, Alan. Anybody else have other comments or feedback would like to about the recommendations? We appreciated what we've gotten so far. Thank you. Anything else? All right then. Well, hearing none, I think what we'll try to do is go ahead to our speaker for this morning. So, not sure, Henderson, if you're going to do introductions or Mercedes.
Well, it's going to be very quick. We're fortunate to have Christina Becker with us to start off this morning's conversation on crimes and fees. Ms. Becker is a colleague of mine at the Capital Punishment Unit of the ACLU. Previously, she was with the North Carolina affiliate of the ACLU, and in that context, led a research and writing effort that produced a report on this same subject. So we're pleased to have Ms. Becker present for the presentation, and we'll take this moment to acknowledge Professor Markham, Jamie Markham, who's also available to facilitate the conversation, the discussion that follows. Professor Markham is at the UNC School of Government. He's done a tremendous amount of work in this area, in fact, in all areas related to sentencing. Christina, the floor is yours.
Thank you. Good morning, everyone. And just quickly to provide an update on the most recent question about the restriction on felony or on voting for felons in Florida. That currently, although the district court found that it was a poll tax and unconstitutional, it went up to the Court of Appeals, was overturned, and the U.S. Supreme Court let that the overturn stay. So right now it's still in the appeals process. So hopefully that helps. And thank you, Henderson, for the introduction. Although I started the project of fines and fees at the ACLU of North Carolina, my journey to fines and fees really started when I was a public defender at Mecklenburg Public Defender Office. What I found was that a lot of my clients were more afraid of having to pay fines and fees and then having the conviction itself on their records, because fines and fees meant that they had to forego other things, and that includes paying their rent and feeding their children. And so much of my job was trying to figure out how to deal with the fines and fees to make their lives a little bit easier. When I started at the ACLU of North Carolina, my sole project really was focusing on fines and fees. And there wasn't much that I knew besides what was happening in Mecklenburg County. So I kind of set out to answer a couple of questions, which is one, what's actually happening in the courts in North Carolina, and who's paying the money? So what I found was an enormous obstacle, which was that there was no data. There was no publicly available data in order to answer any of my questions. What I found a little bit about the fines and fees that were being paid or collected by the state and the amount that was being appropriated to the state from the general fund. However, there was really nothing on who was bearing the burden and what was going on and the processes that were going on in the courts. So I decided to take my show on the road and actually sit in the courtrooms themselves to find out what was going on. I chose 4 different counties to concentrate on, and those are Avery, Edgecombe, Mecklenburg, and Robeson County. And I chose those counties because they were geographically diverse. The populations were different in each one. And just to kind of go over a little bit about some background about each county. In Avery County, approximately 93% of the county is white, 20% live in poverty. In Edgecombe County, 58% of the population is Black. In Mecklenburg, about a third of the population is Black. But what we saw in Mecklenburg is that 68% of the courtroom was Black. So that does not include other people of color, which in Mecklenburg is often Latinx and Southeast Asian folks. And Robeson County is sort of has a unique racial makeup in that it's almost a third Black, white, and Native American. About 29% live in poverty, and about 83% of the people in court were people of color. So as you can see already, just as far as who is in the courtroom is disproportionately people of color. So you can imagine that the burdens placed on them, or the financial burdens then, are disparately placed on people of color. So to to gather the data, I conducted over 400 observations in the 4 counties and at least 100 observations in each county. But to supplement that, I also sent out multiple public records requests to all the counties, to at least four different agencies in each county, hoping that someone would have records or data. What I found, however, that out of 100 counties, only 57 responded with any data at all addressing our inquiries. I don't think there's any county that was able to answer all of our questions. And our questions were fairly basic, as in they were, how many people have been incarcerated for fines and fees? What do people owe in the county? And for the most part, none of the counties were able to answer any of these questions. Most or many didn't respond at all. And I have the breakdown here that you can read. 11 counties reported booking data, 34 counties reported data on the budget, the cost of the jail, because we wanted to be able to compare how much they owed to how much we were paying to keep them in jail for owing fines and fees. There were some counties that weren't even keeping any data. And so there was no standardized data collection at all. So some of the smaller counties didn't have any record of who was in jail over the course of the previous 6 months. Some of them said that they just wrote it down by hand and then just didn't keep it. So I think that gives you an idea of sort of how behind our data collection system is, or the fact that it's fairly non-existent and certainly not a standardized one. You can switch slides, please. So I think the best way to understand what's going on in these counties, and these counties, I think, are representative of the counties that surround them, is to look at the people's stories and what we observed in court and what happened, the stories that we heard when we actually talked to the people who were kind of sitting around waiting for court to happen. Mr. Stephen Edwards was in Edgecombe County. He is disabled. He was in a fatal car accident where he lost his brother, and he also lost one of his legs. He was a farm worker in around Tarboro. He's from Pine Tops. And as you can imagine, when you lose your leg, you are no longer very valuable as a farmhand. So it took him nearly 10 years to get his disability check. And in that time, he pretty much was incapable of making money in a legitimate way. There's no industry around there. And most people work sort of customer service jobs where you're standing on your feet all day. He was arrested for a low-level drug deal. He was the sole breadwinner of his family. He currently has I think she just turned 9-year-old daughter, and a fiance. So Mr. Edwards had just lost his mom when we met him when he was waiting in the court to go in the courtroom, and they told him he was going to be arrested if he couldn't pay. Luckily, we were able to step in and help him out, and he was able to return home that day. He'd even asked for a continuance so he could be there for his mom when she was cremated, and he was denied that continuance, and then therefore was actually in court that day while his mom was being cremated. As you can see, just a little bit about the Edgecombe County sort of data snapshot here. Shows you the presence, the county demographics, which I went over a little bit, and how they compare to the courtroom demographics. As you can see, people of color are overrepresented in the courtroom. And you can see also that there are a few people that had legal representation. Most people were not either were not offered an attorney, even though if they didn't pay fines and fees, they're facing jail time. And either that or, and sort of throughout all these counties, with the exception of Mecklenburg, some of them were actually discouraged from getting any representation, even though they were eligible for it. You can see out of, how many judges actually asked whether or not someone even had the ability to pay. And and 95 of them didn't ask anything. So you can imagine that without information, that the outcome was not great. And that Black people that were incarcerated were 4 times more likely to be incarcerated than white people in Edgecombe County. Mr. Edwards is still struggling, and his family is still struggling today financially, but also with fines and fees that happened prior to me representing him. The next county is Avery. As I mentioned, it's 93% white, but there's still a pretty severe level of poverty. It's, for those who don't know, it's in the western part of the state, in Appalachia and near the Tennessee border. And this is Mr. Brandon Sutton. He was 18 years old when we met him. He did have representation, who said nothing in court. He was being threatened. He has no priors. He was being threatened with 1 year in jail if he didn't pay $1,300 in court costs. Mr. Sutton only made it through the 8th grade. He has a 3rd grade reading level. He has cognitive disabilities and severe social anxiety, which has prevented him from keeping jobs in the past. He had an attorney who didn't know the law. He had an attorney that thought that he would face a year in jail, and probably really was, even though it was an unconstitutional sentence by the judge. And he would have gone to jail, likely, if we hadn't stepped in. We promised to represent him, but his great-grandma, who you can see on the next slide, was really worried that if he didn't pay, that he was going to go to jail. And she was very frank with us and said that she didn't think he was going to survive a year. So what she did was she took all of her heating money, all of her oil heat money, and put it towards his fines and fees before we could represent him in court. And when I asked her what she was going to use to pay to heat the home, she said she didn't know. And so that was the last place that we left them. But one thing we did know is she wasn't able to pay off all the fines and fees. We were able to get rid of the rest, or get the rest waived. And he didn't see jail time for inability to pay. Robeson County had the most egregious stories. And hopefully you were bothered by the first 2, because I think, frankly, anybody can find themselves in that place. But in Robeson County, there was just an enormous amount of people who were locked up for inability to pay. Every month they hold a sort of non-compliance courtroom session. And they gather everyone who couldn't pay or didn't pay and put them all in one courtroom. So there were sometimes 200 people in a courtroom a day. And when I arrived, there were no defense attorneys. Every once in a while, a private attorney would pop in and say, hey, my client already paid this. But overwhelmingly, the people in the courtroom were very poor and people of color. And they had 0 representation. So they were being put in jail right and left for inability to pay. And the judge said that he didn't care if they did extra community service. All he cared about was the money, because the state needed the money. Well, while I was there, a public defender who was fairly new took it upon herself to be in that courtroom and she had to fight to be there. She had to fight to give them representation, even though every single one of them was eligible because they were facing jail time. And when she presented the judge with the landmark case, Bearden v. Georgia, that states you cannot incarcerate somebody for inability to pay, solely for inability to pay. When she presented that case to him, the judge said, I don't care. I don't care what that case says. I don't want to see it. And I don't want to be told what to do by you. So, and that is unfortunately the mindset of many judges, because the pressure by the state to collect money is pretty strong, and they can feel it. And so because of that, you can see out of 110 people, how many people were incarcerated. 11 Black, 13 Native, 6 white, and 2 were, I couldn't get their race specifically. But it was the most out of any county that I witnessed. Now, Mr. Patterson was one of the people that was unfortunate enough to appear in Robeson County. He had 0 priors. He was Shaw University student. He was not eligible for an attorney because he only had class 3 misdemeanors, speeding, and I believe it was failure to register his car on time. He said he would pay if he was given more time. Instead, the judge heaped upon him jokes about jail rape and putting him in prison, and that he wouldn't get out because he was worthless and that he was a disgrace to his university. And it wasn't until we stepped in and helped him with his case that he was able to find any relief. He was given an unlawful sentence when I was observing, and we were able to get that overturned. But Mr. Patterson is just one of many in Robeson County that face the same discrimination and face the same abuse by judges. So Mecklenburg County is a little different. They're not perfect by any means. They still have issues. As you can see, Black people make up a little bit over 30% of the population of Mecklenburg County, but were 68% of my court observations. So right away, you have disparities of representation in the courtroom. But one thing that Mecklenburg was much better at was, 1, giving people legal representation, and 2, asking about people's ability to pay. And because of that, you can see that the outcome is completely different than the previous counties. Whereas out of 100 observations, 1 person was incarcerated for inability to pay. The Mecklenburg County has also created its own task force on fines and fees, and has taken upon itself to review their own policies and their own procedures in the courtroom to make sure that there aren't disparities and that they are considering ability to pay. They've also created their own bench card outside of the state one that Professor Markham will talk about later. But some of the takeaways, besides the stories and the points that sort of exist in all of these stories, are that 1, the noticeable racial disparities and who shoulders the burden of the costs of who pays the fees. It's the poorest of our state, and it's people of color. So 10% of the people we observed in the courtroom were incarcerated for non-payment, for inability to pay. And 78% of that group were people of color, 78%. And that includes an almost all-white county of Avery County. So if you extrapolated that across the state, really, I think that's the 78 number would be higher. Across the state, judges do not hold meaningful hearings to determine one's ability to pay and have assumed the role of debt collectors. And in fact, Robeson County, one of the judges was called the best debt collector of the state by the district attorney in the county. So there's no veil here as to what the judges think they're supposed to do, and that they know that they're supposed to do it for the state. They don't appoint counsel properly. I saw judges, especially in Robeson County, talk people out of getting representation. And they would say, are you sure you don't want to just take care of this today? Because if you get counsel, we'll have to come back. And in order to please the judge, often the people would say, yes, okay, I waive my right to counsel. And they'd say, okay, did you pay? No, go see the sheriff. And they would lock them up anyway with no representation and talking them out of getting it. The average and the practical person in me really wanted to see what we expected to get as a state, and also what we were paying to lock people up. The average cost to jail someone with outstanding court debt is $1,158.68, while a person on average only owes the court $525.48. So that's nearly 3 times the cost that we're paying to incarcerate people and take them from their communities. Right now, there's no system to collect data on how fines and fees operate and practice in the state, and there's no standard practice for implementing fines and fees. This is where we could step in and create good policy, because there's no set of rules. There's no set of rules that judges have to follow, and therefore the outcomes are varied and often unjust.
Christina, what a powerful presentation. And thank you for that. And thank you for the PowerPoint that you've made available to the working group and will be made a part of the record. Just for time's sake, we're going to expedite this section, and we've got Professor Markham here, and we'd like Professor Markham both to report on his work with the forum and how that encourages the guided inquiry that was missing in so many of the courtroom observations that you made. But then we also want to get Judge Locklear Clark's views on where we can go, and then have some opportunity for the working group to discuss. Professor Markham?
Hey, good morning. Can y'all hear me okay? It's good. Thanks. I appreciate the opportunity to be on the call and listen in. I care a lot about these issues, and I think I get a lot of questions about them day to day from court actors. Had a really nice conversation with Judge Clark about it last week. And so it's such a huge issue, but one piece of the puzzle, and I know one of the recommendations is to require consideration of ability to pay on the front end. Christina's absolutely right. It's required on the back end constitutionally before revoking somebody's probation or something like that. But to make that determination on the front end under existing North Carolina law, by statute at least, that's only required when a court imposes restitution. It's not required at the moment that costs are imposed or a fine is imposed, at least not clearly so. There is this litigation nationally that may ultimately get to that place, but there's not a black letter case saying that. And so the idea here was to create a form that guides that determination of a person's ability to pay. And it does include the things that are required statutorily for restitution, which it's really a small part of the puzzle. But then gathers, from examples nationally, from incorporating principles from the ABA and the National Fines and Fees Justice Center, and examples from municipal courts and other courts across the country that have had success with these kinds of things, sort of a fairly predictable set of data points for a judicial official to make a determination about whether somebody could afford to pay one of these obligations without impacting their daily subsistence. So that's the sort of the touchstone of all of it. I think it's a work in progress. Just to be clear, it looks like a real form now because the AOC has started to work on it and flow it into their template for these things. So sort of once you see it in that format, it starts to get real more than, the things that I come up with on my computer, in Chapel Hill. And there's tension between trying to have something that gives a judge a complete picture versus having something that's usable in the practical reality of especially district court to do a full financial analysis of every defendant. It would collapse under its own weight, even if it were the best thing to do as a matter of policy. So trying to make it streamlined enough to be usable both to the judicial officials and to the litigants, particularly self-represented litigants, to not have it be just like impossibly intimidating, like how would I ever fill this thing out, to even know what to ask for is, in tension with the need to get the right kind of information before a judge. So the first 2 pages, the front and back of the first page is designed to gather information, kind of a worksheet of a person's ability to pay. And then the back, the second page, front and back, is meant to be the form that the judge would use to enter the order in response to the defendant's request. And it could be used at sentencing or later in the life of a case, like if somebody was coming back before the court to get things forgiven, even if after their probation is done, for example, to try to undo a license revocation and things like that. In some parts of the state, people are already having success doing that with homegrown forms. This does take input from those. And sometimes the response I get is like, hey, we don't need all this detail in this form. We're having success doing this with a group of judges or a DA who already is on board with it being the right thing to do. So again, the tension there is like, yeah, in those districts, you probably don't need to come in loaded for bear with this, tax information and everything else, but sometimes there will be a more searching inquiry. So it's trying to give people the tools to, that we can train judges and court actors on. So there's sort of a standard of what they could expect to see. And then decide for themselves, both constitutionally and in their discretion, sort of what's important to them and what they think is good policy. I mean, Christina mentioned the cost benefit there, which is well known, and what the right thing to do in a case is.
Professor Markham, I'd like to stop you there.
Sure, sorry.
And one of the values of your form is it breaks out some of the specific functions that these fees are intended to cover. And I was shocked and offended that we've got folks paying for law enforcement office training and law enforcement officer retirement funds. And for every piece and operation of the court system, we're saddling the poorest among us with paying for those obligations. So, and I don't want to be demeaning, but the UNC School of Government is sort of a academic ivory tower, pointy heads reside there. And I'm just curious, whether in those circles, there's actual conversation about whether it's the right thing to do. And I think part of what we are charged with is offering to the governor some recommendations about what can be done to improve racial equity in the justice system. And when I see your form and when I hear Christina's presentation, I'm reminded of what happened in Ferguson and the Department of Justice report on Ferguson, how court fees were used as an intentional part of putting the knees on the throats of poor people, and especially Black folks in Missouri. And I'm wondering, is there a space in North Carolina where this issue is being discussed, the appropriateness of this policy of taxing fees on poor people and people of color?
I think that this is one of those, one of the forums where it's happening. And it's certainly something I get asked about. I think some of the fees you mentioned, where there is no direct nexus between the fee assessed and that defendant's processing through the system, are the ones that I think are most apt to be challenged through litigation. and that has happened to some degree with improper equipment costs and in our recent past, that issues have been all the way to the Supreme Court. You're right to point out, I mean, I care a lot about these issues, and I've spent a lot of time trying to bring some truth to the understanding of what actually happens. I think a lot of time is spent on these issues in court. That is, if people appreciated what actually happened in response to the words said and the orders entered, particularly just to put an issue on the table that I think is important, particularly things that are imposed as a civil judgment. Christina knows that I spend too much time thinking about that. Just for starters, the lack of information people have about what happens then and their likelihood of success of actually collecting money, if that's important to a person in terms of justice in a case. So I feel personally unclear at times about my own role in that. The School of Government is a nonpartisan, non-advocacy institution, and different of us on the faculty interpret that in different ways. And for the time being, I mean, it's reassuring to know that able advocates are litigating some of these issues and pushing for. It's reassuring to me as a citizen, but I want to make sure that I, without avoiding a difficult issue, that I, at least step one in this process of what may be a very long process, and my role in that process is consistent with my understanding of the school's traditions in defining the scope of the problem and helping people understand what their options are. Because what I hear, even as a starting point, is it is a useful addition to the conversation, even just to distinguish, like, hey, not all money is the same. Like, and prosecutors have different reactions to notions of restitution than they do for some of the fees you're talking about, Mr. Hill. So it's to have a more informed conversation about what the different policies might be for those different types of money, and not to lose sight of what's constitutionally permissible, I think is advancing the conversation. So at least for the moment, and I hope it's not viewed as an abdication on my part, that's how I conceptualize my role in that conversation.
Jamie,
Thank you, Professor. And Judge Thornburg is going to make a comment, but let me just offer an apology and an explanation. The pointy-headed reference was completely a joke. I think we all here value the special contribution that scholars bring to it, the ability to step back and to give us perspective. And from a personal point of view, the special contribution of your form, outlining where these fees are going and directed, and giving and almost forcing judges to think about these things as they're explaining it to the defendant who appears before him, is an extremely valuable step. And I certainly don't want any of the sort of lighthearted comments to distract from that. And we especially
no problem there.
We appreciate your appearance. Judge Thornburg?
Well, I would say Jamie's a military officer, and I think he can probably handle it. So he's had a lot worse said. I
also have 4 kids in the house here on a Zoom call, so it's like I'm just happy the connection's still holding up.
I'm going to give you a different way to answer. I'm going to ask the question that Henderson asked in maybe a different way. Have you seen other jurisdictions forming any consensus around what fines and fees are low-hanging fruit to address? And also, that's part one. Part two is, have you seen any kind of consensus, just anecdotally, among my colleagues? And I know I believe I see the issue of supervision fees or jail fees, those sort of things, more often addressed than perhaps some of the others. Do you see either district or superior court judges waiving or remitting certain fines and fees more often than others, and some kind of collective consensus around that among our bench. So those are sort of two issues, two questions there.
Sure. So some of the ones that come to mind quickly, I know your schedule is tight, are community service fees, to the extent that there's people find appeal in community service and working as an alternative to still, have some form of accountability, but without the disparate impact on people without the means to pay. Community service is appealing, but of course you have the problem here of community service having this $250 fee to participate in the program. And that fee, just to compound the problem, does not have a clear statutory waiver provision. So that's, although it gets waived all the time. So that right there is recognition, I think, on the part of many judges that they know something needs to be done to try to allow a person to have some accountability, but without it necessarily being financial. So the $250 community service fee is one that comes to mind. Definitely see the $10 per day pretrial jail fee, to the extent that the people most likely to have that cost imposed are the people that couldn't afford to make bond. And so it loops into that issue as well. And so that's a double whammy for them. So, and those can add up to be, thousands of dollars. And you see that on judgments all the time. In felony judgments that I look at with the Department of Public Safety, like the full cost bill, including jail fees, can be striking. So, but I do see that one waived, particularly in some counties, almost all the time. Lab fees are $600. Those are sometimes waived, or at least not imposed every time they could be. We've had some recent appellate litigation. There's a case called State versus Rieger that calls into question some of the practices people have about imposing multiple lab fees when somebody's convicted of multiple drug crimes. That this case from 2 years ago indicates that it should be imposed only once. Like if somebody has 3 drug charges, it shouldn't be an $1,800 lab fee. It should be $600 and $600 only. But even that, there's a question about whether that is really reflective of the overhead that it costs the lab to perform it. So those are the large sort of single large ticket items like that are the ones that I hear the most about. But more often, what I hear about sort of the mercy given to the defendant is not actual waiver or remission of the fee. It is instead imposing it as a civil judgment, knowing that won't then result in them having their probation revoked for it, or it continuing in many places to result in a license revocation, although in some places it does. But I think there needs to be and I take some responsibility for this. I mean, to the extent that I'm involved in education of court officials, that about what actually happens when one does that, and then also what impact that has on the defendant as to their credit report and ability to move on from the criminal case in a way that could actually last much longer than it would as a criminal obligation on its own. Those are the ones that come to mind.
That's incredible. Those insights are incredibly helpful, Professor Markham. Thank you. Judge Locklear, I know, this has been in some ways an overwhelming session, and I'm not sure how we go from the presentations and Professor Markham's commentary to articulation of specific go-tos, but I think we would all especially value your reactions to the presentation and suggestions for going forward.
Yeah, thanks, Henderson. And I just want to say to Christina, your report was eye-opening. Robeson County is my home, and I've seen a lot of this occur, and now I can do a little more about it in the position I'm in. But yeah, when I read it, although I knew it was happening, it was still kind of shocking. One of my first days as a judge was in the non-compliance court. And so I really struggled with the court. Something that bothered me, however, and I spoke to Professor Markham about this, is that I'm seeing a lot of folks who have the judgments include the maximum sentence. So say, for example, they're charged with second-degree trespass, given a 20-day sentence. They serve the 20 days. In addition, on the judgment, they're ordered to pay the cost of court, which is roughly another $200 with the installment fee, and that's a separate issue. When they fail to pay, the clerk issues this show cause order. When they fail to come to court on that, fail to show up, thinking, gosh, I've already maxed out my sentence, I can't get anything further, an order for arrest is issued. They sit in jail for another month. So now they've done about 50 days, served 50 days for failing to pay monies after they served the maximum sentence. So for me, that's problematic. And when I talked to Professor Markham and also to Shay Denning at the School of Government, they suggested perhaps clarifying the language, and that's in 15A-1364, not to preclude the imposition of fines after a sentence is served, but to preclude the issuance of an order for arrest, I believe. Is that right, Jamie?
Yes, I think those could go hand in hand. And one, right, I just think the statutes haven't been updated to reflect what the current rules about when costs are assessed. Like they were written at a time when people only had costs assessed when they got probation. And they just, the words in the statute don't accommodate somebody that's already served their time. And there absolutely could be a constitutional issue with essentially increasing a person's maximum sentence because they couldn't pay it.
Right.
It's the only way that is constitutionally okay, I think. We don't have a case that says this yet, but it is if it's viewed as some kind of standalone contempt in response to not paying it. But that doesn't even match with existing case law we have about like probation violations as contempt, because those cases say you have to count for jail credit, State versus Belcher, if anybody's taking notes. You have to count the contempt days toward the person's suspended sentence because it's all tied up in the same initial criminal act. So I'm sorry, I'll get off my soapbox. But yeah, that was the issue we talked about the other day. I know you guys want to schedule.
So that's an issue. The other issues, and Jamie has kind of touched on these. One for me is the installment fee. So when a defendant appears before me in court, charged with, it doesn't matter if they do not have the monies to pay on the day of court. And again, it's about 97% of the cases I see that the defendants appearing before me, they do not, that's a lot of money, $200 or $180 to have the day of court, and that does not include the fine. So if they don't have the money, a $20 installment fee is added. And from what I know, there's no additional work that goes into they do a lot. The clerks do a lot, and I value what they do. But I'm not sure an additional burden is placed on them that correlates with the additional $20. And for some folks, $20 is a lot of money. We already talked about the jail fees, $10 per day, the community service fee. I often use community service fee in lieu of paying court costs and fines. I had a couple appear before me charged with larceny, no prior record. It's kind of undisputed that they stole food to feed their family, not working. When they came back to court, when they appeared before me, pled guilty, the husband had just started working. They have no access to any additional monies. So in lieu of paying a fine and cost, I ordered both parties to do community service. And had I imposed a community service fee, $250 times 2 is $500 for that family. There's absolutely no way they could have paid it. So to me, and the statute does not include an express waiver of that fee. I think to clarify the language in the statute to include an express waiver, although many judges don't impose it, it's not there. I think it's just better to be stated. And then of course the lab fees, $600. And I understand that not all labs cost $600. It's just kind of the standard fine we impose each time, when in a lot of cases, it's less than that. So I think it should be the actual cost that should be assessed. We talked about the ability to pay. One issue that we also discussed on Friday with Shay and Jamie was folks on probation When probation is extended for the sole purpose of allowing them to pay their fines, restitution costs, monies, it's simply a money violation, and probation is extended for that period of the extension. And these are for lower level felonies for the most part, or felonies. These defendants are unable to vote. And again, it's because they're poor, or they don't have money to pay. And I think that's concerning to me as well. Something we can perhaps look at. So that's a lot. That's kind of a broad spectrum there. But I think it's important. Again, these folks who appear in court, like Jamie said, it touches a lot of people because money is usually involved in cases. And for a lot of folks, what I see, they do not have the ability to pay. And if we can kind of lessen that burden where appropriate, it would help a lot of people out.
Thank you, Judge Clark. Mike and Mary, we're almost out of time. If there are any comments or questions, particularly on this issue, please share them now.
This is something I'm trying to get up to speed on. I really appreciated Christina's presentation, and especially Judge Clark's recommendations and her providing this context. So.
Yeah, and this is Mike. I do have some questions for Christina's presentation. I'll email them and maybe get some answers. I do think it's kind of a philosophical question that we ought to articulate, and that is that we want people to exit the system with the best chance of success as possible. And that's the whole point of not having onerous fees, is not to burden these folks coming out of the system, not to give them a chance to be successful coming out of the system. And I really think that ought to be articulated some way explicitly in our report.
Thank you. You know, one thing that bubbled up in Christina and Jamie's presentation is the role of discretion. That each, you know, as good as these forms and directions can be, so much is still going to be left to the discretion of the court. And this is a task force or working group with racial equity as its goal. And pockets of discretion have traditionally worked against achieving racial equity. And so I think that's one of the reasons when Professor Markham says, well, there aren't a whole lot of folks talking about, you know, the basic question, whether this is the appropriate policy. You know, this may be one of the few forums available in the state where we can register the position that many, if not most, many, if not all, of these fines and fees are inappropriately taxed on the poorest of our citizens, the most vulnerable citizens at the most vulnerable points of their lives. And that policy question may be one that this task force is especially appropriately designed to raise the red flag. So I think in terms of our mission and our takeaways from Christina's and Jamie's presentation is whether we've got a special obligation to raise a flag to the governor. So thank you for that. We're out of time without having much time to talk about our next business. And you'll see that we've arranged for a meeting of the working group next Tuesday. I think it's one of the most important conversations we have, building very much it builds on some of what jumped out of Christina and Jamie's presentation this morning, that the policies that we're looking at have real world impacts. And when we talk about the knee on the necks of an oppressed community, how we define harm and how the system adds to that harm is an important question that's often not asked. And we take an important first step in that conversation next week. To some of the points that were made before, especially Judge Thornburg, you know, we have got to use our time in between meetings, optimize the use of our time in between meetings. And that will mean offline conversations, offline exchanges, email exchanges within and between the members. We've got folks like Professor Markham at the School of Government. We've got folks like Ben Finholt at the Prisoners Legal Services. And never mind the assets, the research assets that Mercedes and the other staff have assembled at Duke. We've got the capacity to answer questions and to have questions refined. So if it's helpful to have Professor Markham and others help us think through or refine the questions, let's do that, and let's do as much of that in the offline mediums. And I'm happy and would invite being copied on those, but not to slow down the process. So please, members, be active offline. I know this is taking an enormous amount of our time. Yeah, I'm not sure I was aware of just how much time this commitment would take when I agreed to serve, but we made that choice. We're in it now. And so thank you for your commitment. Thank you for the time and energy that you put into it. And yeah, I remain confident that what we come out with will be of help to justice in North Carolina. Mercedes, any other comments before we close out?
No, I would just direct y'all to the PowerPoint slide. There's a link to it on the SharePoint, and it has a lot more detail about a ton of different ideas that we could talk about when it comes to fines and fees.
Wonderful.
Thank you all. We'll see you next week.
Thank you for having me. Thank you.